No one was anticipating Supreme Court Justice Amy Coney Barrett to take on Elon Musk so directly in a dramatic hearing. The courtroom was plunged in a stunned silence as she shook her finger at the tech mogul, her tone firm and authoritative. "Mr. Musk, your conduct indicates a pattern of disregard for established legal precedent," she stated harshly. What happened next left the entire judicial panel in disbelief. Musk didn't flinch or retreat. Instead, he calmly opened a folder, one that would change everything. The legal showdown meant to humble the world's richest man was about to spectacularly backfire. If you want to witness brilliance in real time, watch the full video, and don't forget to like and subscribe for more dramatic confrontations the mainstream media won't show you. The stakes were never higher. The case, Federal Communications Commission versus X Corp, had risen all the way to the Supreme Court after months of mounting controversy. At its core was whether Musk's social media platform had broken federal communication laws by refusing to enforce newly mandated content moderation rules. Justice Barrett, who had been appointed by then-President Donald Trump and is recognized for being a strict constitutionalist, was one of the most respected legal minds on the bench. Even her detractors couldn't deny her sharp mind and commitment to legal exactitude. Musk walked into the respondents' table in simple attire, wearing a dark suit and blue tie, without the flamboyant flair commonly seen on billionaires. Although accompanied by lawyers, Musk had insisted on representing himself to the court, an unconventional and, as many legal observers saw it, too self-assured decision. At first glance, the case of the government seemed rock solid. For months, the press had been reporting X Corp's supposed violations of federal communication statutes. Lawyers forecast hefty fines. The FCC offered a detailed file of noncompliance, with a portrait of chronic abuse. "This isn't just about regulations," the Solicitor General argued in his opening. "It's about whether private companies, regardless of their size or influence, are bound by the same rules as everyone else." What no one anticipated was that Elon Musk had spent nearly a year preparing for this moment, immersing himself in constitutional law and legal precedent. What followed stunned the legal community. Justice Barrett began questioning with her customary accuracy. The courtroom was packed to the brim. Reporters, academics, and viewers understood that they were in the midst of something significant. "Mr. Musk, your platform has consistently declined to adhere to Section 230 amendments stipulated in the 2023 Communications Act," she stated, her voice assertive but calm. "Why do you think your corporation is above rules governing every other communications platform?" "With all due respect, Justice Barrett," Musk responded, leaning in toward the microphone, "that's not precisely true. We've never said we're above legal laws." Barrett's eyebrow rose. "Your behavior indicates otherwise. You've been issued 17 official notices." 16, Musk correctly interjected, his tone even. Barrett's tone grew more taut. "Excuse me. There were 16 notices, 17 is incorrect. And we countered each one with a legal explanation based on precedent." Barrett rifled through her papers. "The record shows the FCC's record is incomplete." Musk cut in, a reaction that seldom occurs in a Supreme Court hearing. The courtroom collectively gasped. Chief Justice Roberts seemed poised to intervene, but Barrett gestured subtly with her hand, indicating that she would handle the interjection. Her eyes compressed. "Mr. Musk, this court has scant tolerance for technical corrections that sidestep the meat of our questions. Our so-called non-compliance," Musk explained, opening the folder in front of him, "was actually a type of constitutional compliance. I think this court would want to evidence that the FCC has intentionally misrepresented us." There was a tension in the room. Justices Sotomayor and Kagan looked at each other, while Justice Alito leaned forward with interest. Justice Barrett's voice became sharper. "This court has very carefully reviewed all briefs submitted. Are you suggesting that essential information was withheld?" "Not suggesting, stating," Musk replied. "The petitioners intentionally omitted crucial information." The Solicitor General jumped up at once. "Your Honors, that is a false and scurrilous accusation." Justice Barrett reacted quickly. "Mr. Musk, that is a serious accusation. In the absence of concrete evidence, such accusations could damage your credibility in this court. Must stay calm. I see, Justice Barrett. That's why I've brought with me documents establishing the FCC's requirements as a violation of 3 distinct Supreme Court precedents, including one in which you wrote the majority opinion. Barrett's face didn't change, but a very close observer might have detected a flicker of surprise. Which opinion? Net Choice v. Paxton, 2024, where you wrote that regulatory coercion cannot compel platforms into government de facto speech content policies by the government's own agencies. The courtroom came to a horrified hush. Justice Thomas, who had thus far been silent, spoke up. You're saying you believe the FCC guidelines fall in that category? Yes, Justice Thomas. And I made a very detailed breakdown for how to prove it. FCC's lead counsel interrupted. Mr. Musk is not a constitutional scholar. His reading of the opinion is deeply flawed and self-serving. Barrett, however, was already examining the documents Musk's team had submitted. Her face remained unreadable, but she studied them with intense focus. Does the petitioner dispute the authenticity of these documents? She asked, addressing the FCC's attorney. The lawyer hesitated. We need time to review what's been submitted. Then, in a dramatic reversal, Barrett turned to Musk directly. You came prepared for this exact exchange. It was not a question, but Musk responded anyway. I did, because this transcends my company. It's about whether the government can do indirectly through regulation what it cannot do directly under the Constitution. The courtroom dynamic had changed profoundly. What had started as a hearing to admonish a billionaire had turned into a defining constitutional controversy. Barrett, never one to skimp on detail, went on. Even granting your FCC overreach argument, your business still refused to heed legal orders as you worked up your case. That is not how the system operates, Mr. Musk. Actually, Justice Barrett, Musk answered, in Youngstown Sheet and Tube Company v. Sawyer. This court held that in the face of potentially unconstitutional orders, parties can request judicial relief before complying if irreparable harm is involved. We requested emergency stays in 3 circuits pending our response. Barrett's eyes narrowed. Musk's legal chops were becoming unavoidable. Those stays were denied, she said. By divided decisions, Musk responded. But Justice Jackson, in her dissent in the case in the D.C. Circuit, indicated that the constitutional questions were serious and worthy of Supreme Court attention. Justice Jackson, hearing her own words quoted, arched an eyebrow in reaction. Seeing momentum lost, the Solicitor General tried to get back on track. Your Honors, Mr. Musk hypotheses notwithstanding, X-Corp continually disregarded federal regulations. Barrett addressed him. Counselor, the very constitutionalness of those regulations is what we're studying. She returned her attention to Musk. Please go on. The ensuing drama would occupy headlines for weeks. Elon Musk, who appeared before the country's top court, delivered a command performance in constitutional law that even his harshest detractors couldn't help but acknowledge. Justice Barrett, please see page 47 in the materials. These internal FCC emails, obtained via FOIA requests, reveal discussions about how to sidestep the limitations imposed by the Net Choice decision. Barrett reviewed the page, her expression growing increasingly serious. These appear to be genuine FCC memoranda. They are, Musk asserted. Notice the bolded quote from Commissioner Thompson. While Barrett's opinion limits our control over content moderation, technical compliance regulations offer a different avenue to the same destination. The court was filled with murmurs as various justices leaned forward to study the documents. Barrett's head snapped up. Mr. Solicitor General, do you have a response to these messages? The government attorney appeared taken aback for a moment. Your Honor, taken out of context, isolated statements can be confusing. The FCC acted in good faith to preserve public interest standards. Musk broke in. The context is contained on the following pages. Agency meeting minutes in which agency officials clearly stated employing regulatory tools as a pretext. Their words, to compel platforms into content policies already found to be unconstitutional by this court. Barrett addressed the Solicitor General once again. Counselor, I would have to read these particular documents, Your Honor, he said. They were not part of the record below, Musk furthered, because the FCC successfully moved to seal them. The documents had been obtained only 3 weeks earlier in a separate FOIA suit that had settled in the Ninth Circuit. Justice Alito broke the silence. Mr. Musk, he queried, are you implying that there was a conscious effort to conceal these communications from the courts? Musk replied quietly. The record speaks for itself, Justice Alito. The FCC knew that these directives ran directly counter to this court's decision in Net Choice. Rather than following that precedent, they attempted to bypass it by using technical regulations. Justice Barrett, who had been skeptical earlier, now leaned forward with obvious interest. Mr. Musk, she said, your position is not merely one of precedent. You're claiming that the FCC acted with regulatory pretext to achieve unconstitutional objectives. Right, Musk said, and not only any unconstitutional objectives, ones expressly prohibited by your opinion last year. It was a striking moment. Barrett, having begun the exchange skeptically, was now taking seriously the content of Musk's arguments. Your Honor, Musk went on, I'm not a trained lawyer, but I've spent thousands of hours reading about constitutional law to prepare for this case. I knew something fundamental was at risk. He referenced Barrett's own words in her opinion in Net Choice. When government power uses regulatory authority to indirectly accomplish what the First Amendment prohibits it from doing directly, courts must be especially vigilant. Somewhere in that line, he said, directed the whole course of our response to the FCC action. The courtroom fell silent. Barrett's gaze locked hard onto Musk. The FCC's requests were not on the basis of technical compliance, Musk said. They were written to try to get us into certain content moderation practices, ones that restrained certain viewpoints. The internal reports make it amply clear that this was always their intention. Barrett nodded slowly. Then she asked a defining question. If your interpretation is right, Mr. Musk, why didn't any other platform challenge these directives on constitutional grounds? Musk's reply was subdued but adamant. Because most companies lack the resources or the will to challenge the federal government. The path of least resistance is often compliance, even if what is being demanded is unconstitutional. I had the means and the will to resist. Barrett glanced back at her notes, then back at Musk. Her tone had completely changed. Your legal argument is much more substantial than I anticipated, she conceded. For a justice who was famous for tough scrutiny, this meant a lot. The Solicitor General attempted one final time to regain control of the narrative. Despite Mr. Musk's claims, he added, X Corp has declined to obey legally issued guidance which has been obeyed by every other site. Justice Barrett responded with quickness. Counselor, if, as Mr. Musk contends, these guidelines were a cover for unconstitutional objectives, then pervasive obedience does not legitimize them. It merely illustrates the chilling effect of overreach in regulation upon constitutional rights. The tide in court had definitely shifted. What started as an enforcement case on behalf of a regulator now bore the hallmarks of a constitutional showdown. Barrett addressed Musk once more. To make clear, your argument is that X Corp never rebuffed legitimate regulations, but rejected unconstitutional government coercion masquerading as regulation? Exactly, Musk affirmed. And we recorded each step of our constitutional protests, even as we were vilified publicly as merely being obstinate. Barrett nodded and then looked at the other justices. Something in the room had turned. What had been intended as a courtroom rebuke of a tech CEO had turned into a serious questioning of the government's actions. The Chief Justice spoke at last. We will require a full explanation of these communications, Mr. Solicitor General. 3 days thereafter, the court went so far as to issue an immediate administrative stay on all FCC enforcement related to the challenge directives. Legal analysts called a major win for Musk. CNN's Jeffrey Toobin, clearly stunned, commented live. This was remarkable. Barrett, who was expected to be Musk's fiercest critic, effectively endorsed his core legal theory. In all my years covering the court, I've never seen anything like it. Media coverage went wild. Terms such as hashtag MuskLegalGenius and hashtag Barrett Musk showdown poured on his social media. Animated recreations of the courtroom battle played on networks, and sketches from artists went viral. Ex-legal clerks and law scholars analyzed Musk's arguments on blogs and podcasts, with many surprised at how exhaustively researched and persuasive they were. I had to Google some of the precedents that he referred to, and I instruct constitutional law, Yale professor Samuel Haverford said in his podcast. Judge Barrett made no public statement, but court insiders confirmed she directed her clerks to initiate a blanket review of all FCC communication surrounding content moderation during the last 3 years. The ripple effects were instant. Other technology titans started re-examining their adherence to the FCC. Google promulgated a review of its activities in response to constitutional concerns raised in court. Meta, the parent of Facebook, filed a motion to intervene in the case as an interested party. Legal journals reacted rapidly. Harvard Law Review issued a special edition to discuss the constitutional implications of the case. Pressure was building on the FCC. 3 commissioners were called to testify in front of Congress. Meanwhile, X-Corp made public documents in which Musk had drafted more than 500 pages of legal opinion prior to the hearing. Then came a former FCC lawyer as a whistleblower. She attested to what everybody suspected, an insider plan to rely on regulatory power to enforce content moderation indirectly. There were candid discussions about relying on rules of compliance as leverage points, she disclosed. We knew we couldn't make it legally enforceable for platforms to implement particular moderation practices, so we attempted to nudge results through technical mandates. Justice Barrett was admired by both parties politically. That she would reconsider Musk's case and take it seriously showed the very judicial temperament she vowed during her confirmation. Musk's own reputation was redefined. No longer just a tech billionaire and engineer, he was now being hailed for legal acumen. Stanford Law School asked him to deliver a guest lecture on constitutional boundaries and overreach by regulators. Although oral arguments would persist, and a final decision remained months off, the case had already emerged as one of the most significant of the digital era. During a press conference outside the court after the stay, a reporter asked Musk where he got his legal expertise. "I'm not a lawyer," he replied with a hint of a smile. "But when something this important is at stake, you make the time to learn." Justice Barrett's writings on government overreach were my roadmap. I just followed her logic. Asked whether he'd tried to change her mind, Musk shook his head. "I wasn't trying to change anyone's mind. I simply presented evidence and arguments that I found to be sound." Justice Barrett is known for intellectual integrity. I trusted her to follow the reasoning, even if it took her somewhere I didn't anticipate. Pundits marveled at the irony. The government had brought the case hoping to publicly scold Musk before the Supreme Court. Instead, he used the language of the court, particularly Barrett's, to flip the script and reveal what now appeared to many as grave constitutional abuses. Maybe the most revealing commentary came from a Supreme Court clerk who wished to remain anonymous, who said that everyone expected David versus Goliath, with Musk as Goliath. But what we got was a constitutional law masterclass from someone nobody thought to take seriously. The case was ongoing, but legal experts were increasingly confident that it would set new limits on government authority and free speech in the internet age. And it all started with a courthouse moment when a justice attempted to question a CEO, only to find he was more familiar with her own concept of the law than anyone anticipated.